One of the most important choices you'll make when forming your sports club is which legal structure to adopt.
The main choice to make is whether your club wishes to be incorporated. Unincorporated clubs have no legal personality, and their committee members are personally liable for any decisions made on behalf of the club. Many clubs in Scotland are unincorporated. This is a suitable setup for small members or amateur clubs with no significant assets, no interest in property, who don't employ any staff, enter into contracts, or get involved in any other arrangements involving risk.
Sports clubs can take one of several different legal structures, the most common of which are an unincorporated association, a private company limited by guarantee, a private company limited by shares, a community interest company, which can either be limited by guarantee or shares, or a registered society, which can either be a cooperative or a community benefit society,
or finally, a Scottish charitable incorporated organisation.
Let's start with unincorporated associations. This is the most common type of structure for an amateur club, largely because it is the easiest, cheapest, and most informal way of forming a club. Unincorporated associations are groups of individuals who are bound together by the constitution or rules of the club. As such, the club is not a separate legal person in its own right. This means it cannot act in its own name to hold property, employ staff, or enter into contracts. Unincorporated associations have fewer legal requirements, are subject to less outside scrutiny, and allow more member control over the club rules and constitution. Despite these benefits, unincorporated associations can leave individuals exposed to liabilities. See our video, Incorporating Sports Clubs, for the benefits of incorporation. All of the 5 other legal structures we will look at are incorporated and offer committee members and individual members limited liability. This means that the amount of money for which you are liable is limited by the business structure, usually to a nominal sum. If the club is to be formed primarily for participation purposes, with no view to members seeking to profit personally from the operation of the club, a company limited by guarantee is the most common form of incorporated legal structure. A company limited by shares is an alternative option for a club wishing to be an incorporated organisation which does not wish to operate on a not-for-profit basis. This legal structure is similar to a company limited by guarantee, except that the company is owned by shareholders who elect the directors. Like the legal members of a company limited by guarantee, shareholders also typically have a right to vote. Companies limited by shares are not normally chosen as the legal structure for clubs which operate membership schemes. This is because each time a member joins the club, a share has to be issued to them, and similarly, each time a member leaves the club, their share has to either be transferred to somebody else or redeemed. A company limited by shares may be suitable for a club which has, or wishes to attract, owners or investors who want to invest in the club as a potentially profit-making operation. These investors can benefit from payments of dividends and an increase in the value of their shares, which can be sold subject to the incorporated club's governing document. This structure, as with all incorporated structures, allows protection for individuals against liability. It also allows shares to be bought and sold, as well as directors to be paid for holding office if the articles allow. Many of the professional clubs seen in the upper echelons of the English football pyramid are registered and set up as CLSs. Community interest companies are limited companies with special additional features. These are created for the use of people who want to conduct business or other activity for community benefit, and not purely for private advantage. This is achieved by the company satisfying a community interest test. This ensures that the CIC is established for a community purpose and making its property subject to an asset lock. This means that any asset held by the CIC may only be applied for the benefit of the community, even on winding up. Individuals remain protected from liabilities under a CIC. A CIC can be any of a private company limited by shares, a private company limited by guarantee, or a publicly limited company. A CIC is suitable for a club which wishes to operate as a social enterprise. This can either be formed as a company limited by guarantee or as a company limited by shares. Some donors will only give to charities or community interest companies because of the protection these vehicles provide their funds. Access to finance, whether through donors, grants, or community development finance, may lead a social enterprise to operate as a CIC rather than as a standard company. There is also a lower level of ongoing governance for a community interest company than other bodies, such as charities. While CICs are regulated by the CIC regulator, this is a comparatively light touch, with the main requirement being the submission of the annual Community Interest Report. However, unlike charities, CICs have no special tax advantages, even if their objects are wholly charitable. This means that, all other things being equal, they'll potentially raise less money for their cause than if they were established as a registered charity.
Examples of clubs registered as community interest companies include Stenhousemuir FC.
A registered society is a body regulated by and registered with the Financial Conduct Authority. It can carry on an industry, business or trade for the benefit of the community. Once called industrial and provident societies, a society must now either be a cooperative society, formed for the benefit of its members only, or a community benefit society, a business conducted for the benefit of the community at large.
Examples of this include Annan Athletic FC.
In most cases, a community club, adopting this legal structure, would be set up as a community benefit society. This status allows individuals to be protected against liabilities, no limit on the number of shares which can be issued to its members, as well as a sense of public involvement due to members tending to have one vote each, regardless of investment.
The final legal structure we're going to look at is the Scottish Charitable Incorporated Organisation. A SCIO is a structure only available to charitable organisations in the UK. A SCIO is a legal form specifically designed for Scottish charities. SCIO status is granted by the Office of the Scottish Charity Regulator on application by a charity, whether new or existing. In order to be eligible for charitable status, the legal entity must be non-profit distributing. This would exclude a club owned by a small group of shareholders. There is scope, however, for a community benefit society issuing community shares to be recognised as a charity, though that is a new development in Scotland and there are few examples to date. Charitable status brings with it the need to comply with charity law, and those serving on the board have certain legal duties as charity trustees. The requirements are not particularly onerous, and the charity trustee duties are broadly in line with what would generally be regarded as common sense principles supporting good governance. Clubs registered as charities are unable to pay players, unless for coaching as part of a wider community setup.
If the club does have charitable purposes, but intends to trade, for instance to sell tickets, merchandise, food or drink for a profit, it may have to consider establishing a trading subsidiary. Watch our video on charitable sports clubs for more information. Charitable status does bring a range of benefits. For example, people may view your club differently as a charity. Charities also often enjoy considerable support from funders and other potential supporters and can claim gift aid on donations. In addition, charities can run certain fundraising activities that may be banned or require a license for non-charities. Charities are also able to claim a number of tax reliefs on most income and profits. These can all make an important difference to the amount of money your club can raise to support its cause. More locally, they're typically eligible for a substantial discount on business rates.
The disadvantage of registration as a SCIO is if the club decides to stop being a charity, it also loses its incorporation status and reverts to being an unincorporated association. Although SCIOs are growing in popularity, it is important to note unincorporated associations, companies and societies can also hold charitable status. However, SCIOs are solely registered with the OSCR and only regulated by charity law. This reduces upfront paperwork and ongoing filing obligations, which can lead to cost savings and is advantageous to trustees with no previous knowledge of running a company.
For more information on these different legal structures and which might suit your club best, please head to www.clubdevelopment.scot.
Regardless of the legal structure you choose to pursue, or if you're simply looking for more information about the options or are ready to incorporate, get in touch with us to discuss how we can support you with the process and help you grow a winning club.